let me give you some caveats before we start. First of all, this is my understanding from some research that I've done. And second of all, this is more of the highlights. Some of this stuff may be nuanced, but I'm not going to go into the little details because we don't have 3 hours to talk about it. In order to understand Iowa's merit selection system, I think we have to go back way before Iowa was a state and talk about the judicial system in general. The Declaration of Independence was basically a list of grievances against the king. Many of them, I think 6 or 7, maybe up to 10, were about the judicial system that was in the colonies. But the two most relevant ones were, and I'm going to read this because I don't have a great memory on this, he being the king, he has obstructed the administration of justice by refusing his assent to laws for establishing judicial powers. He has made judges dependent on his will alone for tenure of their offices and the amount and payment of their salaries. So basically, the colonists recognized that judges were making decisions based upon the way the king wanted those judges to make decisions because he actually controlled them. So when the Constitution was enacted, it allowed for a lifetime appointment of judges picked by the president, affirmed by the Senate. At that time, many states did the same thing. They had lifetime appointment of judges. I know Massachusetts still does, although they have a 72 age retirement. And I think there's a few other states on the East Coast that still have lifetime appointment of judges. However, things changed when Thomas Jefferson was president. When Thomas Jefferson was president, he was upset that the judiciary seized the power through the claim of exclusive judicial review, Marbury versus Madison. He was afraid that they would become the supreme deciders over the other two branches. So what he did, well, let's back up a little. Supreme Court judges at that time also rode the circuit. So you could be a Supreme Court judge on Monday and you could be in Delaware on Tuesday hearing a trial. But what they did is that he wanted to show that the other branches of government were the supreme branches of government. And we're hearing that now, that judges are answerable to the people. So what he did is that he contacted an ally in Congress, and his name was Joseph Hooper Nicholson of Maryland, complaining about the judicial power. So what the Congress did in the House of Representatives, they impeached Supreme Court Justice Samuel Chase. If you read the articles of impeachment, they were basically based on some decisions he made while riding the circuit. They didn't like the outcome, so he got impeached. His defense was that he was just relying on precedent, that prior precedent. Well, the case went to the Senate, as it did for a trial, and in 1805, the Senate acquitted him. And they established the premise that a judge is independent and that a judge cannot be removed from office for a decision that the legislative or the executive branch disagrees with, as long as they're fair and impartial and they're following prior precedent. Well, that didn't sit too well with the states. So after 1805, many states who had lifetime tenure for judges started electing their judges. Some were partisan, some were nonpartisan. And that happened for a while. Well, Iowa became a state in 1846, the 29th state. And there were 3 constitutional conventions, 1844, 1846, and 1857. 44, I don't think they passed the Constitution, but 1846 and 1857, there were 2 constitutions. And if you read the debates of the constitutions, they were really deciding how judges should be selected in Iowa. And they had various ways. There was a New York plan they talked about, and some of the stuff is if you heard about it, you wouldn't agree with it, so I don't want to get in all those details. But the bottom line is they went to the election of judges. And that happened until 1962. Something happened in the 1950s in Iowa that caused the state to rethink it. I've heard various things. Some people say it was the right thing to do because adopting the Missouri Plan. I've heard and I've read that there were some scandals in Polk County dealing with the Republican governor. The Republicans controlled Polk County back then, if you can believe it. But there was a scandal and everybody got voted out, including the judges, and that was unacceptable because you want the judges to be there as long as 10 years you can, because believe it or not, judges get better the longer they're there. And that's a real principle. You take the bench and you have certain biases and prejudices, but as you're working through it and going through it, judges end up becoming real judges. I remember my first year on the Iowa Supreme Court, I'd write a proposed decision, and Justice Turnus would come in my office and say, "Are you Justice Wiggins or Senator Wiggins?" So I'd have to rewrite the thing. So that's important, and over years I think I became less and less partisan, although I don't think it was partisan at all, but less and less, my writing showed less and less of that. So in 1962, the Iowa Constitution was amended for merit selection system. It was backed by both Republicans and both by Democrats, and the League of Women Voters were the driving force behind it, and a constitutional amendment was passed. It still required a retention election, and I think the people who did it, who put the amendment through, realized that unless you have some kind of input by the people, it probably wouldn't have passed. So there was always that retention element where you need 50% of the majority, 50% majority in order to retain your seat. Well, one of the flaws of the amendment was that the amendment set forth the way the commissions are to be set up. The district nominating commissions had equal number of lawyers, equal number of lay people. Lawyers were elected by the members of the bar, and not the Iowa bar, but the members who were on the roll of the Supreme Court. And the lay people were appointed by the governor, and one person, a judge, was the last person, so there'd be an odd number. And in the district court, it was the most senior judge of the district court, which could have been the chief justice at the time, or chief judge of the district. On the Supreme Court, or the state nominating commission, there was no court of appeals at the time, but on the state nominating commission, it was an equal number of lay people, again appointed by the governor, an equal number of lawyers elected by the bar. And on the Supreme Court, or the State Nominating Commission, there had to be one from each district, congressional district. That's how they did it. And on the, or it might have been two, but it had to be equal around the state. I think there were two from each district. And there was the leader, or the chairman of the commission, was the longest serving justice other than the Chief Justice, because the Chief Justice was in the Constitution. So the flaw with the thing is that where they set up the makeup of the commission, and let me back up a second, on the state nominating commission, the members appointed by the governor had to be approved by the Senate. On the district nominating commission, there was no approval, but because the governor didn't appoint the majority of the people, I think our founders of our Iowa Constitution said that you don't need the Senate safeguard on the district court, but you needed the safeguard of the Senate on the state nominating commission. And in order to get confirmed in Iowa to these commissions, you need a 2/3 majority of the Senate. So if a third plus one of the Senate said no, you couldn't be confirmed. And I think we saw last year 2 or 3 of the governor's nominees to the state nominating commission were not allowed because the Democrats had enough votes to stop it, and the governor had to pick 3 more people. But the real flaw in the system was where they set up the making of the commission. They said, until July 4th, 1973, and thereafter, unless otherwise provided by law. So they only set up this system for 10 years. And after 10 years, as otherwise provided by law, the law being whatever the legislature does, or another constitutional amendment. So in summary, the way the commissions were set up with equal lawyers, equal lay people, and 1 independent judge was only good for 10 years. What happened was a string of cases came down from the Iowa Supreme Court, together with some governors not being able to get their people on the court. Most recently, it's been in the Republicans. They didn't like that. So what they did is the legislature on the state nominating commission removed the judge, the Supreme Court justice, from the state nominating commission and gave the governor that pick. They took the operation of the commission from the Supreme Court, it was the court administrator who did it, to a private commission. So it's really not run by the state, by the Supreme Court anymore. And the governor got or received the extra pick. So now there was a majority of people on the commission who were picked by the governor. But you still had that Senate being able, if the Senate thought they were too partisan or something was wrong, that they could be denied their position. But it was all politically motivated. And the other thing you want to remember is that at the same time they did that, we had a Chief Justice, and the Chief Justice was reappointed, I think, every 8 years on their term. They changed the term of the Chief Justice to 2 years, and I think that was based upon trying to remove Justice Cady over the same-sex marriage and the abortion cases we had. And there is some question as whether some of the justices on the court were actually working with the legislature to do that, which is something that came up at the time, and I'm not going to say any more about that. But it happened on a Friday, and there were some phone calls made, and the bill came out on a Friday when it was supposed to be dead for that session. In any event, the real problem today is that after the elections, there's now a supermajority in the Senate, which means that the Republicans control who gets appointed and who doesn't get appointed. So if a Republican governor appoints somebody, I'm sure there's not going to be Republicans who are going to say no. But the same will happen if, things change. We're going to get a Democratic governor in the next 5, 10, 15, 20, maybe 30 years, and we may have a Democratic Senate, and it's going to go the other way. But the problem is there is no more safeguard on the governor when you have a supermajority of appointing anybody to the court. And you don't want to kid yourself, because the people who are appointed by the governor seem to be in the same view as the governor, and are on a mission to appoint people who have those same views. So that's where we are now. So it turns out we went from appointed for life to elections to a merit selection system, and basically we're back to electing. We're pretty close to electing judges again, and there's no safeguards from the Senate, at least in the federal system, when there's no supermajority, or they got rid of the filibuster rule. There were some safeguards, although we saw last time when President Trump was president, you only needed 50%, and President Trump was able to put 3 justices on there. So the federal government's basically the same way. But there are some questions that I think lawyers and I think members of the bar and people in this state need to answer and consider. First of all, could the legislature further change any of these commissions, including the district court. There's been bills in the legislature, and there's been a movement, at least in the last few years, to remove the judge from the district court commissions. If they do that and the governor gets that appointment, there will be a majority of the governor's appointees on the district court. Two, because the commission is made up by the legislature, could the legislature remove all lawyers from the commission? Give lawyers no input anymore? I mean, there's nothing to stop them from passing that bill to remove all lawyers from the commission. So it's something as a bar association and something as a member of the public need to consider, because lawyers are probably in the best position to say who's qualified to be a judge and who's not qualified to be the judge. And three, maybe should we go back to electing judges so we know where everybody stands? I don't know the answer to that, but it's pretty political in the last 10 years in Iowa, and I have a funny feeling it's going to get a lot more political over the years. Because if the legislature feels that the lawyers are being obstructionists and not allowing certain people to get out of the commission, because lawyers are pretty persuasive in the commission, because I was the chair of the commission for probably 5 years, and the lawyers, you know, talk candidly about people and are pretty persuasive. If they feel that the lawyers are stopping some of the people they want in the court from getting out of the commission, what's going to happen? And the other thing is, there's one other change that I think is significant. They raised the Court of Appeals to 5 appointees instead of 3 appointees. Why don't they raise it to 10 appointees? I mean, the more appointees, the more people you get to send to the governor, the less discretion the commission has in weeding out people, and the more discretion the governor has in appointing someone. So that's my little summary. There may be some nuances in there, and there may be other things, but that's my take on it. And it is my opinion. I want to say that. It's not anybody's opinion, but that's what my research has shown. Well, first of all, a judge is able to tell the lay commissioners as to what a judge should be and what attributes a judge should have. The judge is also, if the judge is fair and impartial, as they should be in deciding cases, they should be fair and impartial in those commissions and should not force their will